I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Saturday. Hope you're all doing great. It's a great day. Let's say hi to some people in chat. Abby, Michelle, Leanne, Neil. I saw Rich. I want to say KG. Kagi. I don't know how to pronounce your name. I'm really sorry, but thank you for being here. And don't feel dirty. It's really not that bad. Mindy, hello. Hello, everybody. Thanks for being here. Thank you. James, hello. All right. We got some fun clips. We got some Saturday arraignments. And the first one is very interesting. Very interesting. Jude Curio, welcome. Rick, welcome. Jay from Michigan. Hey, Jay. Hey, Jay. Michelle Eaton. I said hi to the other Michelle, but I need to differentiate. Hey, I said that word correctly the first try. It's gonna be a good stream. Dr. Steph, welcome. All right. Got a good video for you today. I'm taking the night off. I'm gonna spend some time with Heather. So let's watch some court. Before I hit that play button, you already know what to do. Hit that like and subscribe. Do your jump kick backflips. Let's go.
On February 8, 2024, Officer Johnson, Thompson, and Peterson in full uniform, fully marked scout car, dispatched to 15734 Rutherford for felonious assault. Upon their arrival, they spoke to Kimberly Shelton, the complainant, who stated that Jacob Langston, the defendant, came to the location, threatened her with a firearm over a sex toy. The complainant further stated that she was inside of the home when her handyman, the defendant, came to the side door. And
with her handyman, right? Her handyman is not the defendant. She was in there with him?
With the handyman.
Okay, thank you.
To the side door and demanded that she give him the sex toy that he gifted her. The complainant further stated that the defendant didn't point a firearm at her. At that time, she pretended to call the handyman manager, but called 911 for police assistance. The complainant further explained to the officer that then she got into the vehicle as she was on the phone with 911, and the handyman and her son got into the vehicle as well, and the defendant left the location. As officers were still doing their investigation, the defendant pulled back up to the location, and that's when officers were able to detain the defendant to continue their investigation. Officers did not find a firearm or in the defendant's vehicle. During the investigation, when the complainant stated that she wanted to proceed with charges against the defendant, I spoke to the defendant, who stated that he went to the location to get the sex toy, but he did not have a weapon, nor did he own a weapon. End of testimony.
All right, thank you. All right, I do find probable cause to support the charges here, although I'm a little concerned that no weapon was actually recovered, but he did leave the scene and then come back. So I will find probable cause to support the charges. Now, wait a minute. All right, testimony as to prior convictions, please. We've got an FIP here.
Okay, 62397 3rd Circuit Court Criminal Division. He has a felony warrant for carrying a concealed weapon, to which he was found guilty. And he has another one for police assaulting, resisting, obstructing, to which he was found guilty. End of testimony.
And what is the domestic relationship of these parties? There's a domestic violence charged here.
If they were boyfriend and girlfriend. Let me make sure.
Don't you worry, Hector. That answer or that question is, well, you know what? It's never answered. But during the arraignment, this is just a swear to. During the arraignment, Prosecutor Vincent does his best not to laugh. That's coming up right after this. Yeah, she's gonna be on my live for my 10K live whenever that happens. I'm a little over 500 subs away. Almost at 10K. We're getting there. But yeah, she's gonna be on for that.
Yeah. Boyfriend and girlfriend for 3 months.
Okay, thank you. All right, then I do find probable cause to support the charges, signing and sending on for processing now on that one. Now we've got People versus Shantia Rayleigh. This one.
All right, that was the swear to. Had to add that in there just to give some context to what is going on here. And as always, Prosecutor Vincent does not disappoint. He's awesome.
Hi, what's your name, please?
Jacob Langston.
Okay, Mr. Langston. People versus Jacob Langston, counsel.
Good afternoon, Steve Vincent for the people.
Jessica Scheib on behalf of Mr. Langston, who is formal reading, understands constitutional rights and stands here.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Langston's behalf. Mr. Vincent, is this one that you were able to review?
Yeah, I did review this one. Thanks, Judge. This one was a little interesting to me, Judge.
Okay, go ahead and do your appearance first, and then I'll appearance.
No,
Steve
Vincent, P71917.
Thank you.
Yeah, Judge, I don't know. I know it had to deal with the sex toy. I don't know if the sex toy had sentimental value or if it was encrusted in diamonds or what, but this defendant allegedly had given the complaint this sex toy and he wanted it back. It could have been worth a lot. And we didn't find that out in the investigator's report. However, with all of that being said, Judge, it is a Habsburg notice. The most recent conviction I found was in 2007 for an R&O. I think what we would do.
All right, encrusted in diamonds. Look at the judge or the magistrate. Just look at her. She literally she leaned back in her chair. She's like, what is he talking about? This is awesome. I love how Prosecutor Vincent literally demands everybody's attention every time he's talking. And I love that about him because everybody stops what they're doing and they listen to him. Just look at her. She's listening. She already knows, like, what is he about to say? He's good at his job. That's what he does. He demands your attention when he speaks, and he grabs it from his opening statement, and then you listen to him throughout. She's no longer reading the report. She's listening. It's a really good job.
Judge, we would just recommend a high personal possible monitorization because it seems like there were, weapons involved and there was some type of an assault that was had, but at the very least, Judge, no contact whatsoever through the pendency of this case. And I'll just leave everything else as it is.
Okay, thank you.
There are no objections to a personal bond, asking the court to not consider the tether, not on probation or parole, nothing pending, no capias. His last conviction is from 2007. He is employed, and Your Honor, he has custody of his two kids full time. So respectfully asking for that personal bond.
All right, thank you. This is one of those cases that at this point is strictly a he said, she said. There's no evidence, no corroborating evidence, no witnesses that I can see. There are not, a firearm was not recovered when they did come into contact with Mr. Langston. So, there's very, very little evidence at this stage in this file. For that reason, I am going to give a personal bond in the amount of $50,000. You are not to have any contact with the complainant, sir. That means no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact will be considered a violation of the conditions of the bond. You are not to return to the address on Rutherford where this is alleged to have occurred. You may not go back there. And you are not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Next court date, February 21st for probable cause conference at 8:30 a.m., February 28th at 8:45 a.m. for preliminary examination. Both of those in front of Judge Giles. Thank you.
February 20.
Yep, you'll get this when you
Okay.
leave.
Thanks, Judge.
Thank you.
See, we can see eye to eye on some things.
Oh, yeah, I think we mostly do. I think your requests are generally pretty fair.
Yeah. That one I just didn't want to touch, no pun intended.
Stop. Stop.
All right, come on. That was funny. That was funny. That one I didn't want to touch. No pun intended. Yeah. All right. All right. The next one, we started off with something kind of funny. DV isn't funny, but the facts of the case were kind of humorous, right? So next case is serious. And I don't know who watched this already this morning, but just listen. I put the swear to in here just because the arraignment does not give justice to what happened. So listen to the swear to, and everybody make sure you're safe with your online purchases. Check your account statements very regular, because this could happen to you.
Well, how are you, sir?
I am doing very well. So both of these matters are yours. You want to start with, well, what do you have in front of you? I've got both.
My swear to encompasses the probable cause for both subjects. If there's any clarification needed, we can break it down, but I'm ready to swear out the warrant for both of them simultaneously.
Okay, so let's do this. So calling case prosecutor order number 24-12806, as well as prosecutor order number 24-12806, the same exact complaint number, two separate defendants, but the swear to factual basis will be exactly the same other than the defendant's names. Is that correct?
That's correct, Your Honor.
Okay, so we're going to start with, so calling prosecutor number 24-12806 relating to both defendants, Dagnat, URSEIU, and Andrea, ANDREI, last name DRAMBA. So let's go forward with the facts at 128-06 in the matter of Dagnat Urisa. Detective, please state your name for the record.
Detective Brett Nelson of the City of Royal Oak Police Department.
Okay, so you have your right hand raised. Solemnly swear and affirm the testimony you're about to give us truth to the best of your knowledge, information, and belief.
I do.
Okay, please state the facts as you know them to be in this 10-count.
All right, before we get into this, I've asked you guys this before, but it was about a month ago. Do you guys remember why you raised your right hand? Just a little trivia question. Just checking to see if you guys remember or if you know. Because I did not know and I looked it up, and it's actually fairly interesting. I don't know what's more interesting, why we raise our right hands or the fact that we still do it.
Filed against URSEIU, the defendant.
Thank you, Your Honor. This is in regards to Royal Oak case number 24-4502. And again, the swear to is going to encompass the facts for both defendants, including the one we just named. On February 7th, 2024, Royal Oak officers were dispatched to the Walgreens in Royal Oak at 30852 Woodward Avenue. A caller called and they observed a suspicious man doing numerous ATM withdrawals and cash outs. Officer Loved and Handrinos arrived at that Royal Oak Walgreens and located the suspect, who was later identified as Danut Ursiu, inside the store. Officers attempted to investigate Danut. However, he quickly fled from them on foot. In the process, he ran directly into Officer Handrinos' chest, violently knocking him out of the way. Danut led officers on a foot pursuit across Woodward Avenue traffic to a getaway vehicle that was waiting for him in a nearby parking lot. Danut entered the back seat of that getaway vehicle, a gray Ford Edge that was driven by driver Andre Dramba. Officers were in full uniform. Officer Love drew his service weapon and issued loud verbal commands, which Dramba and Danut disregarded. Danut exited that vehicle again and again fled on foot. Andre fled in the vehicle and drove the vehicle away from officers against their orders. Andre reunited with Danut, picked him up, and fled south on Coolidge Avenue in the suspect vehicle up until the point they were boxed in and stopped by the Berkeley Police Department. I should note I did a search warrant for the suspect vehicle in-car computer called infotainment system. That infotainment system was forensically analyzed and dumped, and it actually showed Andre reached dangerous speeds of 86 miles per hour in a 35 mile per hour zone, traveling southbound on Coolidge while fleeing from officers in this case. Danut and Andre were both apprehended and arrested during that box-in traffic stop by Berkeley PD, and after which officers recovered over 250 cloned financial transaction devices from Andre and Danut's possession. Each of them were in possession of 10 or more cloned financial FTDs. Those cards were located within the suspect vehicle and also from a jacket that Danut was seen wearing before he discarded it. Those financial transaction devices were scanned. They were found to be fraudulent and altered, with hundreds of stolen account numbers re-encoded onto them from numerous financial institutions. The fake financial transaction devices also had stickers on them with the individual PIN codes that were assigned to each account. I conducted some follow-up investigation. I learned that both Danut and Andre are members of a known international criminal organization that they entered the country both illegally to commit skimming offenses and financial transaction device fraud across the country. Both men are currently being investigated by numerous law enforcement agencies around the country for similar offenses. I followed up with numerous victims whose account numbers and PIN numbers were in their possession. Those account numbers combined with the PIN codes constitute the victim's PIIs. It's unique to each individual. The victims included those listed on the warrant for the identity theft counts for Mr. Danut. It includes Mr. Callahance, Mr. Fairbanks, and Miss McGee. And with that, Your Honor, you have the warrant before you.
All right. I didn't want to pause it while he was talking. So raising the right hand is religious. It does have something to do with religion. I don't know when they might have always done that with the Bible. I don't know. But yeah, you put your left hand on the Bible and then you raise your right hand. But the raising the right hand, this is a tradition that came from England back before records were kept on individuals. So there was no paper trail of a criminal history. They would brand the hand of criminals who essentially accepted plea deals. Say, you had a domestic violence, whatever they called that back in the day. I don't know. They would get a mark on their hand. So when you raised your right hand and you swore you would tell the truth, the judge or the person that was questioning you would see the brandings on your hand and could see what you've been charged with in the past. That's why you raise your right hand. Now, I don't know if they've always put their hand to the Bible, or maybe when they stopped marking them, that was their way of checks and balances by putting your hand on the Bible. I don't know. I don't know when the Bible came into it, but yeah, they used to make you do that too. All right. Johnny, you're here. Johnny, when are you going? Oh no, Johnny, when are you going live, Johnny? Did I miss your live? Usually you go at about 4, and I just realized it's 5 o'clock. What time are you going live today, buddy?
Thank you. The court finds that the alleged crime was committed, probable cause to believe the defendant committed the said offense as it relates to Dan Nutt, URSEIU, the 10-count warrant. The court will sign and issue the complaint and warrant in this 10-count matter. The court also finds, as it relates to the same complaint number, 24-12806, the court finds in that matter as probable cause to believe a crime was committed and probable cause to believe the defendant, Andrea, ANDREI, Drama, DRAMBA, also committed that offense as well. The court will sign and issue the complaint and warrant in both these matters as it relates to both defendants in this matter. Detective, other than what I, kind of have in mind already, any thoughts on your behalf as well as that you wanted to tell the court about Vaan?
Yes, thank you, Your Honor. I have quite a few thoughts on this. First of all, as I mentioned, both of these men are members of an international criminal organization. They were smuggled into the country for the purposes of furthering a fraud conspiracy. They're known to have committed numerous similar crimes in numerous states. I've seen estimated fraud loss details out of some states that are in excess of $1 million. Due to the nature of the crimes they commit, they are essentially printing money. So as it pertains to bond, I believe it's highly likely that they are generating a tremendous amount of illegal cash and therefore may have the ability to post a large bond with proceeds of their illegal activity. I think it'd be worth considering making a bond nebia or bail source hearing necessary if they are able to provide bond to prove their source of funds. I did not mention this in the swear to, but it should be known that both subjects had very convincing fraudulent out-of-country identification documents that were fraudulent. They lied about their names. Even once they were in custody and questioned by members of Homeland Security, they continue to lie about their identifications. We had to search high and far to actually get their actual IDs. We believe them today. So the point being, I believe they'll go to great lengths to evade capture. I believe they're going to continue to commit crimes. And I believe that if they are out on bond, it's unlikely we're going to see them again. They have no known permanent residences within the state of Michigan or in the U.S. They are known to stay in short-term rentals and travel all around the country. So I also believe that based on our interaction with them, there's a legitimate concern. They pose a great danger to the public, the manner in which they assaulted an officer to get away and then caused a great danger to the public by fleeing from police at high speeds. I think in addition to the financial implications of their crimes, they're also dangerous to the general public. So I would suggest in light of all that, I think even a bond up to as high as $1 million per person would be appropriate.
Okay, thank you, Detective. I made notations of your thoughts as well as bond recommendations in this matter. We will be arraigning these individuals quite shortly. My understanding is that are they at your department or are they in the Oakland County Jail?
Yes, Your Honor, they're still at the Royal Oak Police Department.
Okay, we will be arraigning both these individuals shortly. Thank you very much.
Sure, appreciate it. Thank you, Your Honor.
On case prosecutor order number.
All right. So we got two gentlemen essentially skimming credit cards. I don't know what they're doing, but they have, I don't remember the numbers that was said, but an insane amount of devices, an insane amount of cards with the PIN numbers on every card that have been duplicated. That's why I said, check your statements, see what's going on, check your statements regularly, just to be safe. Even if you don't want to look at how low your balance is, if you're me, it's still safe to see, just to make sure. It's scary. It's scary that these guys can just come into the country and do this. And I'm glad the officer said that. It's like, I want $1 million bond. I saw the $10 million comment. I would have said no bond until you can actually figure out who these guys are. I don't think they should leave. I know everyone's innocent until proven guilty, but with this amount of, I don't know what to call it, evidence in their car when they got pulled over. Yeah, they were driving 83 and a 35 to get away from the cop. I'm sorry. I would hold them until you know exactly what's going on. I know that's not how the way the court works, but that's how my mind works.
24-12806. I'm going to spell the Danut, D-A-N-U-T, last name U-R-S-E-I-U. Counsel appearance for the record.
Good morning, Your Honor. Nicole Smithson, P71404, appearing on behalf and with the defendant for arraignment purposes only. Had the opportunity to speak with them, advise them of the 10-count warrant.
I think they said that Homeland Security interviewed him. I think that was part of the. Maybe that comes up now. Sorry if I just spoiled it. I'm sorry, but there was another department that interviewed him, or maybe they're waiting for an interview. I don't know. The officer, I think, said that. Like I said, if I'm wrong, it comes up right now.
the maximum penalties as well as his rights. We'd waive reading, stand mute, ask the court to enter a not guilty plea. He is requesting court-appointed counsel. Regards to bond, he's 31 years old. He has one child. He is currently unemployed. He does acknowledge he has some criminal record. We are asking for a reasonable cash surety, 10% bond, and he is more than happy if the court wanted to place a GPS tether on him to ensure his presence in court if that court would be inclined to grant a lower bond because of that.
Okay, thank you.
Yeah, sorry, Bob. I'm taking the night off. I've been busy. I've been busy this morning. For those of you that didn't hear the other night, Judge Slavin is going to be on my channel on Monday night. We're going to be doing a live stream together. I've been busy trying to get all that stuff together. So I'm hanging out with Heather tonight, so I'm taking the night off. And time just flew by today. You know, when you're working on something so hard that you don't look at the time and then all of a sudden you look and it's 3 hours past. That's what happened today. So I am sorry for the lack of heads up. That's why I put the notification on my community tab or whatever that's called on YouTube. I don't use that enough and I need to get better at using it. But yeah, I do apologize for that. Bob, thank you for hanging out though. I appreciate it.
Counsel. Sir, at the jail, would you please state your name for the record?
Urseyu Danut Valentin.
Okay. Okay, the court's prepared to set a bond in this matter along with other conditions. Counsel, just for your information, I'm not sure if your client even lives in the state or even in the country at this point. I'm not sure whether or not the client has any different or additional names in this matter. So that's giving the court some concern, not to mention the allegations in this matter. Your client did in fact attempt to elude police during this incident where an officer was assaulted. At least the allegations are that. So that gives the court some concern about possible danger to the community in this matter. I'm not ready for you to talk yet. Okay, you'll get your chance. Hold on a second. There was attempts to flee the location at high rates of speeds by the co-defendant in this matter, I do believe, driving. So based upon the fact that not sure where the defendant is residing or even if he's a resident of this state, this country, I'm not sure where you would get to mail. Based upon that, the court has some serious concerns about the assault of nature, as well as the allegations, as well as the possible plight of the defendant not appearing at his next court appearance, based upon I'm not certain as to whether or not he's a resident of the country or even plans on being here long. The court will set a bond in the amount of $1 million, cash surety, no 10%. The court is also going to order that the defendant be placed on a GPS tether prior to his release. There will be a hot zone. That hot zone, sir, indicates that you will not leave the city of Royal Oak until this matter is resolved. Other than that, I have some additional conditions. The defendant will not have any direct or indirect contact with the complaining witnesses in this matter. John Chahallance, Chillalance, Bradley Fairbanks, Jolie McGee, Joelia McGee, or any contact with the co-defendant in this matter. I'm going to spell the name, Anrei, last name Drama, Dramba. You will not have any contact with any of those individuals that I just listed off. You will not assault, beat, molest, or in any way verbally harass intimidate, or threaten any complaining witnesses in this matter, personally appear for all court appearances, not leave the state of Michigan without permission of the court, immediately notify the court in writing of any change of address or phone number. You will not possess any firearms or other dangerous weapons. You must contact Pretrial Services Division within 24 hours should you bond out on this matter. That would be at the 44th District Court in Royal Oak. Other than that, pick up no new criminal offenses if you end up bonding out. As I indicated, you have been granted court-appointed attorney in this matter going forward. Other than that, sir, do you understand your bond conditions, sir, at the jail?
Excuse me, mister. I don't understand with who.
Nefertiti, I think you misread that. It was an explanation about what I said. I made an example of why you raise your right hand in court, and I used DV as an example. But we're talking 200 years ago when the reason why, not maybe even no, it was probably like 400 years ago, 4 or 5, where there wasn't written records, and you raised your right hand, and they used to mark your hand for your previous crimes, and I used DV as an example where they would mark it. So you read a comment about that. So yeah, you I think you missed the context. So no, they weren't saying DV is a new thing. That's not what that person was saying. It was the charge of DV is fairly new. I think that's what they were saying, not anything about the actual crime. I hope that cleared it up. Sorry to pause it, but I wanted to clear that up because that's important, because I saw that comment too, and yeah, if you missed the context of where it came from, I can see where you thought that.
I'm not allowed to get in contact.
Not quite sure what you said, but let me start over again. Do you understand your bond conditions, what I've read off to you? That's my first question. Answer that first, then we'll go forward.
And matter of fact, I understand. I don't understand just one thing.
Okay, tell me what that. Slow down a little bit. Slow down. What is it? Other than, I know you understand everything I've said, but there's one thing you don't understand. Please tell the court what that is.
With who I'm not allowed to get in contact.
He said, who is he
Okay.
not allowed to be in contact with?
I heard that. These are the alleged victims in the current criminal matter pending, as well as the co-defendant in this case. So let me tell you. So it's several individuals: John Challant, Brantley Fairbanks, Jolie McGee, and the co-defendant in this matter, who I suspect you are aware of. ANREI's first name Fernando, MIHAI, and last name DRAMBA. You are not to have any contact with those people. Those individuals are somehow a party to this criminal complaint against you, and therefore you are not to have any direct or indirect contact with them whatsoever. Phone calls, meetings, emails, whatsoever, no contact. So that's what that means. We don't want to have any communication between you and those parties. So you're all set now, sir?
Okay, I understand.
Okay, best of luck to you, sir. Counsel?
Your Honor, did
Yes,
you
go
say
ahead.
did you say if he bonds out, he's not allowed to leave the city of Royal Oak?
Only because that's what I indicated. Only because I don't have a valid address on him within the state of Michigan. If he somehow comes up with a
Mister, but they don't let me have a phone call so I can fix everything.
The counsel, if he somehow comes up with a valid address where we can have home confinement at a valid address somewhere within a reasonable distance of the court, even if it's within the state of Michigan, by the time he gets to his next court date, that could be addressed. So, sir, your next court date, and you'll get a copy of this, it would be within the next 10 days you will be in court again. So your next court date is your probable cause conference, which is scheduled for February the 20th, 10 days from now. That's February 20th of 2024. And you also have a court date after that, which is your exam, which is scheduled for February 26th of 2024. Both these matters are going to be heard at 9:00 a.m. in the 44th District Court in Royal Oak. Okay, so I think we're all set now.
could you put the carve out exception with the exception of court appearances? My only concern is that the PCC will be by Zoom, and should he bond out after the PCC, the court appointed attorney is not going to know that that's a bond condition because we don't get the bond conditions given to us when we get the appointment order, and everything else is going to be at the circuit court.
So, but the court appointed attorney would be able to contact his client in person, wouldn't he?
Yes, but I mean, he might not think it just might not come up. Generally speaking, we don't discuss bond conditions.
Okay, so what was so mention that point again, counsel. I want to make sure I understood exactly what you said. Repeat that condition you would like added.
If you could just put a carve out for court appearances. My concern is just that he might bond out after the PCC and then he need to go to the 1200 building, and I don't want him to get a violation because he's going to the 1200 building.
Okay, so GPS tether prior to release. I indicated already, do not leave the city of Royal Oak, which is where his probable cause conference and exam is going to be held within the city of Royal Oak. Was there, you're saying there's more you would like?
Yeah, except for court appearances to the 1200 building.
Oh, okay. I understand. Now, the reason I didn't put that in there is because by the time he get to his next court date, if it ends up being at the other location, but I'll just add it in there, regardless, a carve out just for court appearances.
Thank you.
Okay.
All right, we're gonna go on to the next guy. Same dude, or the co-defendant. Let's do that. Jude Curio for the 1 month. Thank you so much. Here's the many more. Exactly. We're gonna be around for a while. Clyde, welcome. Thank you for becoming a member. Welcome to the family. Every Monday, Members Monday. This Monday, I will be doing a live stream with Judge Slavin. We're gonna be reacting to a soft sit video. But I will do a members only video before that. It's going to be earlier in the day. So maybe 1-2 p.m. Eastern time, I'll do a members only video. I've already got the video picked out, and it's kind of wild. There's a guy serving a long sentence. He's serving, I think he's 10 years in jail. He's been in jail for about 6 years, and he sued another inmate and was given a judgment of $4 million. It's fairly interesting. It's very interesting to watch. So that's the members only video that's going to be on Monday. And again, Nefertiti, I saw your message. Nobody's saying that DV wasn't a thing until recently. And the only reason I'm responding to this is because I don't want to misconstrue anybody. I seriously believe the comment that you're referring to was because it wasn't a charge. There wasn't a charge of DV until, I don't know, when did a DV charge actually hit the books? Within the last 100 years. My reference was a couple hundred years ago when that wasn't a charge. I'm not saying it was right, wasn't saying it was right back then, but there wasn't a charge of that. I had a bad example of people being branded on their hands so the courts could see what they were charged with because records were not kept. Just want you to know that is not what that person was saying. They were saying that I had a bad example. I should have picked a better example, is what that person was saying. So I hope you're still here and I hope you heard that. All right, let's go to the next guy.
Okay, counsel, is this another person or the same person?
We're going to get the next person, sir.
Yes, thank you. We're done with this individual. Thank you.
Yeah, we're gonna turn your phone on. You gotta go right now. You gotta ring your buddy.
No, you're done, man. You're not gonna. Hey, sorry, can you turn cell one phone on?
Try that again.
That's a good question. If you come up here on Monday, I will let you ask that question. I would love to hear the answer to that question. So make sure you're here.
Okay. Calling case prosecutor order number 24-12806. This is in a matter of, I want to spell the name, Andrei, first name Fernando, Mihai, last name Dramba, Dramba. Counsel appearance for the record.
Good afternoon, Your Honor. Nicole Smith, MP 71404, appearing on behalf of the defendant for arraignment purposes only. Had the opportunity to speak with him, advise him of the, I believe, 11 count warrant, the maximum penalties for all 11 counts as well as his rights. We'd waive reading, stand mute, ask the court to enter a not guilty plea. He is requesting court-appointed counsel at this time. In regard to bond, he is also 31 years old. He has no children. He's currently unemployed. He has no record in the United States. He did finish what would be high school in Romania. We are asking for a reasonable cash surety 10% bond.
Thank you, counsel. Sir, at the jail, what is your name? What is your name, sir, at the jail?
Sorry?
What's your name?
Dramba Fernando.
Counsel, I will indicate a plea of not guilty on your client's behalf. I will grant court-appointed counsel in this matter as well. This is the co-defendant to did not URSEIU. This is the co-defendant in this matter. There was some allegations in this matter that the defendant in this matter fled the location, possibly putting other folks in danger, driving at an excessively high rate of speed. There is no known address that is listed for your client. I'm not sure if he lives in the state or even in the country. I'm not quite sure where he is. So the court obviously has concerns about your client returning to court to answer these charges. So I'm going to keep the bond conditions based on where I kept the other files. So the bond in this matter, as it relates to this client, exactly the same for the most part as to the co-defendant. Bond will be 1 million cash surety, no 10%. I'm not sure if the defendant has any additional names, but the allegations in this matter are quite disturbing. The defendant will not have any direct or indirect contact with the complaining witness in this matter, John Chalance, Chillance, Bradley Fairbanks, Jolia McGee.
All right, I just want to say, it has been 1 month since I was remonetized. Seeing the 2 months come up today, it didn't hit me that people were members for 2 months until just now when I saw Sally Ports. Yeah, it's been 1 month from today that I was remonetized. It's been a month, guys. And there like I said, there are only, I think, 5 or 6 people that kept their memberships through the time that I was demonetized because it automatically canceled. And I think you had to actually opt in to stay a member to be, I don't know, recertified. I don't know. So there are a handful of people that have the 3 or 4 month, but to see the 2 month today is amazing. You guys are amazing. I have the best community on YouTube. You guys are all awesome. Thank you so much for being here. Yeah, while we're watching these 2 people that, again, you're innocent till proven guilty, but being caught with everything you're caught with, driving 83 and a 35, yeah, I would turn them over to the federal government. Oakland County, I'm sorry that they're dealing with this, but yeah, again, check your credit card statements, check your bank accounts, do it regularly. It's the only thing you can do to fight this. They're going to take your stuff. If they want to take your stuff, they will. That's the unfortunate news about it. They can. If they want to target you, they're going to get your information. So just be vigilant. Check it. That's my public service announcement for the day. All right, let's finish this. And then after this, we get on to Judge Van and we can go back to laughing.
And the defendant will not have any contact with the co-defendant in this matter, Denut, URSEIU. The defendant will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten any witnesses in this matter. Personally appear for all court appearances, sir. Do not leave the state of Michigan without permission of the court. You need to provide the court with an address immediately if you should bond out, and as well as a phone number, because currently you don't have one listed. You will not possess any firearms or other dangerous weapons. You must contact pretrial services within 24 hours of your release if you should bond out. That'll be at the 44th District Court in Royal Oak. Pick up no new criminal offenses while this matter is pending. As with your co-defendant, you will be placed on a GPS tether prior to your release from custody. I indicated a hot zone indicating do not leave the city of Royal Oak until this matter has resolved, except for where a court appearance may require you to go outside of the city limits. I did grant court-appointed counsel.
No. Come on, man. Not only did I already play that, I played it this morning. I told you in the chat of a court, I don't remember which one it was, that I was playing it, and you said, great, I can't wait to see it. You doing okay, man? I hope you're good. But you knew I was playing it. You knew when I was playing it. And then you didn't even go. I do like you. You're a good dude. And I'm teasing you. I know you're good. And you're going to come up with, oh, shit. Yeah, you said that and I just passed it by because you were watching some case about diamond encrusted sex toys. I get it. Don't worry, I get it. This is my best Judge McConaughey voice. I get it. You know, maybe they were in the corner beating themselves up and you were watching that instead of my video. I get it. PR bond to no for this infraction.
In this matter as well, and enter the plea of not guilty on your behalf. Sir, do you understand your bond conditions?
Yes, I understand.
Okay, counsel, anything further?
No, Your Honor.
Okay, then we're all set here. Good luck to you, sir.
Thank you.
Yep.
We'll turn your phone off.
All right, I probably could have waited 10 seconds before addressing No. But No is a really good friend of mine, so I'll address him when he asks questions. You know, the privilege of being a good friend of mine. Anyways, we're going to Judge Van. Just like a couple nights ago, I just played a portion of his docket. This is a portion of his docket. There's a couple really good ones. There's a lot of good interactions between Judge Van and I don't know who she is. She's not a clerk. She's a deputy. I believe she's an officer of the court. I don't know. I don't know what her position is, but the interaction between them is always priceless. Got about 20 minutes of that. And yeah, that's it for the video. And I'm going to go hang out with my girlfriend. You guys are all awesome. Let's keep going. I think I missed something. Oh, Rich. Yeah. When I said, here we go. When I said there was like 5 or 6 members that didn't lose, that kept their membership, Rich was one of them. Got Rich, Heather. I know Debbie's one of them. No, now I feel bad because I don't remember. There's only a couple, and I yeah. This is why you don't talk live about stuff like this, and you just let this go, and you just say thank you, Rich. I appreciate it, buddy. Anyways, Rich is making my thumbnail for my Judge Slavin interview. It's not an interview. Judge Slavin will be live with me, answering questions and watching a sovereign citizen with us on Monday night. So everybody, just a warning, 8:30 on Monday night. It's already scheduled. It's happening. Judge Slavin's going to be hanging out with us. He's going to be on stream with me and answering questions. Make sure you're there. It's going to be fun.
State your name.
Skylar Virgin.
Surgeon for court charge of interference to custody, lewd and lascivious battery, use of child in sexual performance, and possession of sexual performance of child. Do you understand the charges?
Sir?
You understand what you're charged with?
Yes, sir, I do. I don't at the same time. I'm very lost for words. There's so much that y'all don't know.
Don't tell us
And I know
today. Don't tell us today. Don't talk about your case. Listen to the judge.
All right, ma'am. Based on your application, if I do qualify, I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deb, my history?
It's the battery in 19.
Holy cow.
Sit. 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 Go ahead.
I do. $100 right here. $100 says I interrupt right now. I win. Did that work? Yeah, probably didn't work.
All right. So on the interference of custody, bond set at 5,000, the lewd and lascivious battery, 10,000.
How much?
5,000. And possession of sexual performance of a child, 5,000. These are like, I'm missing zeros, I think. On all of them. No. Yeah. Usually 2 zeros on some of them. But here we are. I've read the complaint affidavit and I'm finding that this is a different circumstance than is normally alleged in these kind of situations. So I am reading between the lines. Your court date's going to be March 11th at 9 o'clock. No contact directly, indirectly, or through a third party alleged victim. That's the easiest way for you to screw this up.
Yes, sir.
Your first 2 broke up. That's what I was trying to tell you. We didn't catch all the bonds.
Oh, well, I mean, it's probably because the system broke down because it was so amazed at how low they were. 5,000 on the interference with custody, 10,000 on the lewd and lascivious battery, 5,000 on the use of child in sexual performance, and 5,000 on the performance of a child.
Oh yeah, that's low for you.
There's some zeros missing.
You are missing a few.
Do we have a prosecutor today?
1 0 on each of the charges and 2 zeros on one of them probably, but But here we are, again, I'm reading.
You healed her?
I healed her? Be healed. There you go, Stella, you can love it.
Next. State your name, ma'am.
That was way too low, and the judge knew it too. He's like, "What did I do when I signed this? No idea what I did, what I was thinking." And then she just got off the floor and stopped throwing a little temper tantrum. Be healed. Yeah, sick crime though.
Ms. Gutso, you for the court? Tuso. Say it. Tuso. I can trust myself. Ma'am, before the court on a violation of probation for a possession of cocaine charge in front of Judge Stevenson. You understand that, ma'am?
Yes, sir.
Judge Stevenson has set a monetary bond on your DOP. Circuit judges, they're like getting soft. What's going on? Bond is $10,000. Court date is February the 28th at 9 o'clock. Good luck to you, ma'am.
Yes. Yes. Yep. Step to your right to the T.
And they're old age. I say that about the ones that are
Come
younger
here.
than me.
Oh. Come here. Next.
You called her in there and then you sent her away. Why you got me muted? I want to hear what's going on. I need to hear.
Talking about you. I came for the theatrics, but I obviously missed it.
Oh, I thought it was just me.
It is.
Don't worry, here come another one.
Okay.
Next.
After this.
State your name.
Marco, before the court, charged with violation of probation for uttering forged instrument, grand theft, less than 5,000. You understand that charge, ma'am?
I think that was my good news. I've been working hard today on. I rewatched the video, so I sent him the video so he can watch it and he can review it, so he's ready. And I was working with Rich on the thumbnail, talking about the potential risks of having a judge live on a live stream. But yeah, that was the good news. That was the big news, at least. And yeah, Monday night, 8:30. Judge Slavin and I, we're gonna be covering the South Sid. It's you guys have seen the case. Pretty much everyone's seen the case. It's the woman in front of Judge Gauthier, that, yeah, the South Sid, the contempt hearing. So I waited a month for the hearing to kind of die down and sent it to him. And yeah, that's what we'll be discussing on Monday night. Come hang out with us. It'll be fun.
You understand why you're here? The VOP.
The violation of probation, yes.
Yes, correct. Your order held out bond. Your court date is March 14th at 9 o'clock. Good luck, ma'am.
Step to your right to the T. He can't change it, no. State your name, ma'am.
Stephanie Escobar.
Ms. Escobar, you're for the court on a violation of probation DUI. You're also on the docket for a violation of community control for resisting officer with violence and battery on law enforcement ×4. You understand those charges?
I'm on, okay, so I got those were the original charges, but I'm on VOP for not providing a new address and for not showing up to my probation appointment.
Right.
Yeah, I'm sorry. I just thought you were charging me with more battery on the Leo.
No, that's what I just have to tell you what those are the original charges you were on probation for.
Okay. Yes, sir. I saw you guys, so I do have the warrant has been issued for the DUI.
You've got a warrant for the DUI. That's a $5,000 bond. Your court date is February the 28th at 1:30.
Okay, all right, thank you. Yes,
On the violation of community control, you're held without bond. Your court date is March 14th at 9 o'clock.
yes, sir.
All right, step to your right to the T. When the light comes on, fine. Next.
Hold on.
Next.
Can I? Go ahead.
Son, you step on the X. State your name.
James Simon.
Report charge domestic violence battery. Do you understand the charge, sir?
Sir?
Do you understand what
I
you're
didn't
charged?
Do you understand?
Yes, sir. Yes,
I
sir.
understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Based on your application, I find that you don't want a public defender. You're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
Yes, sir.
Okay.
This is, okay, thank you.
No history.
All right, Mr. Simon, I'm going to release you on what's called pretrial release. You need to be at the pretrial release office after court on February the 12th. Court date is February the 12th at 1 o'clock. You're going to have no contact directly, indirectly, or through a third party, the alleged victim.
Step to your right to the T. When the green light comes on, sign. Next. Red X, sir, state your name.
Mr. McGee, you're fully court charged driving under the influence. You understand the charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Based on your application, I find you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
I didn't hear you. I'm sorry.
You've got an attorney. I've given you an attorney.
Okay, that's fine.
Yeah. Deputy Colin.
Yes, sir.
22, DV strangulation, 18, marijuana over 20, paraphernalia, 14, keeping a nuisance vehicle, paraphernalia, carrying a concealed marijuana, and it goes back to 7 with a DWLSR.
Bond's 2,500, no alcohol. Court date is February the 12th at 1 o'clock. Good luck, sir.
Mimi, he would be an amazing interview. I've got a couple feelers out there for the next judge I'm interviewing. I think I'm going to try Judge Vaan. I think he would do it. I really do. He seems like a personable. Can you say those back to back? I don't know. He seems very personable to be open to it. Oh, Mimi, thank you so much. I'm going to try. And I'm going to give you credit if it happens.
All right, step to your right to the T. When the light comes on, sign. State your name.
Joseph Melton.
So, Mr. Melton,
Yes, sir.
full court charge false ID to a law enforcement officer. You understand the charge?
Yes, I do.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir, I have.
Based on your application, I find that you do qualify. Go ahead, appoint the public to represent you, so you have an attorney now. Any question about that?
No, sir.
Yeah, criminal history?
I couldn't hear you.
20, possession of weapon and mobile felon, possession of meth, paraphernalia resisting, false ID, VOP. 19, some VOPs, 18, controlled substance, paraphernalia, DWLSR, VOPs. It goes back to 1999 locally.
All right, bond set 2,500, court date 12, that's 1:30. Good luck, sir. I'm sorry, 1 o'clock. 1 o'clock.
Appreciate it.
All right, step to your right to the T. Next. Red X, sir. State your name.
Mason Buckler.
Mr. Buckler, you're before the court charged with obstruction of justice. That is a weighty charge. You charged with justice. Let's let them sit there for a second. That's just strong.
All I did was just say something to,
No. I'm stopping you. All right, yes, sir. Don't talk about the facts of your case. All right, buddy. Mr. Buckler. All kidding aside, because it's really just a resisting charge. You do qualify for the service of the public defender's office. I'm going to appoint the public.
Both my daughters do ballet, and one of them was just in the Nutcracker this past December. So yeah, maybe that's what I do. I'll just start wearing a tutu. I'll wear a tutu and do a backflip. Don't get too excited.
To represent you. So you have an attorney now, and he's going to tell you, don't talk about the facts of your case. Boyd?
Yes, sir.
See? All right.
Don't talk about your case.
All right. Deputy, criminal history, Mr. Buckler?
You got him on felony probation.
Case number?
23, 14, 25 CF.
I just completed house arrest and the work program, and I was doing really good on probation.
Well, good.
Did you
Maybe
forget?
the judge will take that into consideration. But see, here's the problem with probation. It's a debit-only relationship. You really don't get a whole lot of credit. It's like being married. You can come home every night for a year. You go missing for one weekend, and that's all she wants to talk about.
She talked about it?
Yeah, no, I would.
It'd been in a black garbage bag on the porch.
All right, man. I'm signing the warrant for violation of probation case 23-14-25. And on the obstruction case, I'm giving you a monetary bond of $2,500 just so that you get credit on in the Bay County Jail for the time that you're in that. Your court date will be February the 12th at 1 o'clock. Good luck, sir.
All right, step to your right to the T. When the light comes on, son. Ready, X, sir? State your name.
Travis Miles.
Mr. Miles, you're before the court on a failure to appear for a driving license suspended revoked and no motor vehicle registration that was originally in front of Judge Grammer. You understand that, sir?
Yes, sir. They just brought me from Jackson County Jail. I've been locked up since the 26th of December.
Yeah.
And been for your hold. I mean, is there a way I can get pre-trial or something?
No, it's $4,000. Your court date's gonna be Monday, February the 12th at 1 o'clock.
Yes, sir.
All right, step.
Thank you, Phil, for bringing this up. I brought it up a couple times. Your comment, it does help me a lot to, if you want to, donate to the channel. It helps me out more using the link tree instead of YouTube. On that note, I have a couple people to thank from last night that came in late that I didn't see. I got MB. MB's always very generous, and Cynthia. Both of you, thank you so much for your super chats last night. You sent them in. I figured out how to mute my email. And unfortunately, muting my email, I don't get the notifications anymore. So I don't want the dings, but I want to know when people super chat me. So I apologize for missing those last night. Thank you both. I don't see either of you in the chat. I was hoping one or both of you would be here. The next time I see your names, I will call you out. But if you're rewatching this, thank you so much for your super chats last night. But yeah, Phil, thank you so much. It helps me out more than you know to super chat me that way. All right. Let's go.
Step to your right. Next. Well, step on the X. Face the TV. State your name.
Edward Shippey. Mr. Shippey, before the court for possession of fentanyl with intent to sell or distribute and possession of paraphernalia. You understand the charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right, so according to your affidavit, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. Any question about that?
No, sir.
You also have the option of hiring your own attorney or represent yourself. Deputy, criminal history?
Just a battery and 14, and that's it.
Possession of fentanyl with intent, 1,000 paraphernalia, random UAs, court date's gonna be March 4th at 9 o'clock. Good luck, sir.
First bond broke up.
50 and 1.
Thank you. Step over to the T.
Mr. Barry, your full court charge of escape, possession of paraphernalia, possession of meth, and possession of fentanyl. You understand the charges?
I understand them, but I didn't try to escape.
I did
Okay.
not ask.
Yes,
See,
sir.
It's a very important distinction, right?
Yes, sir.
All right. I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right, sir. Based on your application, I find that you do qualify. So go ahead and appoint the public defender to represent you. Question about that?
No, sir.
Yes.
21 fleeing and elude, lights, high speed resisting, reckless driving, domestic in 20, and an old disorderly in 15.
Is there
What,
any way
Nora?
I qualify for pretrial?
No.
Okay.
On the escape, bond's 5,000. I'm treating it more like a resisting, since you didn't get out of the back seat. On the paraphernalia, it's 1,000. On the meth, it's 5,000. On the possession of fentanyl, it's 10,000. Court date's gonna be March 14th at 9 o'clock with random UAs. Good luck, sir.
Step to your right to the T. Next. Right X, sir. State your name.
Hector Rodriguez. Mr. Rodriguez, you're really court charged with grand theft. You understand that charge?
Excuse me?
Do you understand what you've been charged with?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy, criminal history?
16 in Florida was a grand theft. 16 in Illinois, DWLSR, and Ohio, grand theft 14.
All right, we've only got about 6 or 7 minutes left of this video. Johnny May is offering to wear a kilt if you guys get this video to 100 likes. I'm just saying. I don't know if you guys saw that message. I didn't see it till just now, but get it to 100 likes and he's going to be putting on a kilt. Matt, that might cause you to dislike the video. It might cause you to like the video. I have no idea. But yeah, enjoy the content. That's what we do.
What brings you down here from Chicago?
Was visiting, so I was gonna meet up with some ladies.
Awesome. Bond said 25,000. Court date's going to be
How
March
much?
11th, 9 o'clock. No contact with alleged victim.
March 11th, okay, what's my bond?
25,000.
Pay 10% or?
10%
Wait,
of the bond.
step on the T.
I'm sorry,
Step on the T.
on the T,
When the green light comes on, sign.
right here?
Yes, sir. Red X, sir. State your name.
Mr. Thompson, you full court charge of possession of a forged driver's license or ID card. Do you understand that charge?
Excuse me?
You understand what you're charged with?
I'm seeing you giving copies of paperwork and advised of your rights. That's true?
Got a copy of your paperwork? Were you advised of your rights today? The right to remain silent.
Yeah.
All right, sir. Based on your application, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. You also can hire your own attorney to represent yourself. Deputy, criminal history?
No history, no tracking.
I said at 2,500. Court date's going to be March 4th at 9 o'clock. Good luck, sir.
Thank you.
All right, step to your right to the T. Wait. When the green light comes on, sign. Next. Larkin. Red X, state your name.
Sir, you're full of court charge of possession of meth, possession of paraphernalia. You understand the charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that? Deputy, criminal history?
Shows some sentences in 23, 1 FTA on a misdemeanor in 23, some juvenile grand theft and false reports in the LL.
Grand theft.
Mhm.
Juvenile stuff. Worry about it. Sunset 5,000 with meth, 1,000 paraphernalia with random UAs, 4 days, March 14th at 9 o'clock. Good luck, sir.
All right, step to your right to the T. When the light comes on, sign. Next. March the 14th, step on the X, state your name.
Zachariel Cabrera.
Calero's bonded out.
He bonded out.
Mm-hmm. Preset.
Yeah. Y'all gonna get caught with those. Y'all gonna get somebody.
Well, not me.
Somebody's gonna get
Oh,
bonded
yeah.
out. They got something going on. All right, Mr. Cabrera, you're fully court charged with grand theft. You understand that charge?
Yes.
I understand you should copy the paperwork and advise of your rights. Is that true?
I didn't hear you. You said what?
Been advised of your rights today?
Yeah.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you, so you have an attorney now. Any question about that?
No.
Deputy Criminal History?
Out of Illinois, from 14 to 24, a lot of shoplifting.
Thank you so much, Phil. This is a good time to peace out. There is 2.5 to 3 minutes left of this video. I'm going to peace out. I'm going to let the video play out. Thank you all for coming. Thank you for the memberships, the new members. Clyde, thank you for becoming a new member. Jude, thank you for the 1 month. Sallyport for the 2 months. And and my good friend Richard the Dick Harris for the 3 months. You guys are all awesome. Well, I was gonna say welcome to the family, but yeah, I need to get better with words. Do you guys agree? I need to get better with words. You guys are all awesome. Thank you so much. Yeah, like I said, I'm taking the night off. I'll have a video or two out tomorrow before the Super Bowl, but every single time I say I'm done, Craig is the legend of the channel next to Fred and Craig. But Craig, thank you so much. I very much appreciate it. Super generous super chat. Thank you so much. I don't know what else to do besides say thank you. I mean, I can cry for you. I don't know if that's gonna, do anything for you, but thank you. That helps me so much right now. Thank you. I appreciate it. You're amazing. Like I said, Craig's been a legend on the channel since I was demonetized. I think that's when Craig came around and started watching my videos. Could have been earlier. I'm not sure, but thank you so much, Craig. You're awesome. And Flying Monkey, you guys. I mean, this is me like putting my hand up to say stop, and then my other hand is saying keep coming. Flying Monkey, thank you so much. Late fee, Flying Monkey, you don't need to pay late fee. I appreciate the super chat. The late fee is the like button. That's the late fee, but I very much appreciate the late fee. Monkey, thank you. You guys are awesome. Hold on, I'm trying to catch my words back from what just happened. Thank you, Craig, and thank you, Monkey. All right, I think there's one person left of this. I'm trying to catch my words. There's one person left of this. You guys are all awesome. My community is awesome. The Law Tube community is awesome. Like, let's be fair. It's not my community, and I say that a lot. It's not my community. It's the Law Tube community. The Law Tube community, for the most part, is awesome. I'm gonna say like 99% of the Law Tube community is awesome. So, no, stop, Craig. No, I'm not gonna stop. Not gonna stop, Craig. Can't stop. All right. Craig and Flying Monkey and everybody. I don't know if you heard. I've said it a couple times. Monday night, 8:30 p.m. Eastern Standard Time. Judge Slavin will be on my live. Craig. I can't even get an announcement out to close out the video. Craig, thank you. Thank you. You are trying to get me emotional. You are awesome, Craig. You are again the legend of the channel. All right. What was I saying? Yeah. Monday night, Judge Slavin will be live with me reacting live to a video. Monday night, 8:30 p.m. Sorry, I'm trying to focus. Oh, yeah. And then our friend shows up. All right, yeah. So he will be on and we'll be watching a video. I already know. I already know, Joshua. I already know you're going to be there. We've already got plans for it. You're more than welcome, Joshua, to come up here and not on stream, but you're more than welcome in the chat. We're not going to block you. But I'm going to respectfully ask you to be civil. This is the best way I can say it. We're not going to block you. We're not going to block your comments. We're not going to hide you. But I have already told my mods to be on the lookout for inappropriate questions. Yeah, if you have some jurisdiction questions, okay, Joshua, here's the problem. I'll tell you what the problem is. You have an open case right now in his court. Not in front of him, in front of Judge Shackelford. He can't respond to your questions. He can't. He can't and he won't. I'm just warning you right now. I'm calling you Joshua because I'm not going to call you by your YouTube name. But if you have a honest question, he will answer it. But it's not going to be it's still in his courtroom. It's an open case in his courtroom, man. He cannot answer a question in an open case. He can't. It doesn't matter if he recused himself or not. It doesn't matter if it's your case or not, man. It could be a case in California. If it's still open, he can't talk about it. It has nothing to do with you. He can't talk about it if it's an open case, and you have an open case. He's not gonna, and yeah, I won't bring those questions up, and he's not gonna answer them. You can have a jurisdiction question all day long, man. You can, but if it's an open case, he can't answer it. That was the number one rule he gave me when he agreed to come up. He cannot talk about open cases, and you have an open case. He will not. How many jurisdictions does the court? Hold on. How many jurisdictions does the court operate under? I don't even know if that's a real question. Adam Young, thank you so much for the congrats on the remonetization. It's been 1 month today. It's been a great month. I've got a great support. I've got a great community. The LawTube community is amazing, which is what I've been saying for the last 5 minutes. That it's great, and I'm so happy for everybody. I'm so happy for the community. Yeah, it's good. It's good. I'm sorry, guys. I'm really paying attention to Joshua. You know what? No, I'm not going to do it. I've got plans tonight. I was going to say I'm going to bring Joshua up so he can ask me questions, but I got plans. I got to go. Yeah. Again, feel free. I've already told my mods not to block you. You're more than welcome to come on to. I keep saying come on. You're not coming on stream, but you're more than welcome to be a part of the live community. You're more than welcome to ask questions. I don't know if he's going to answer your questions. He knows who you are. Yeah, Monday, fair game. He's going to be on my stream on Monday, man. And we already know you're going to be there. We already know that. Like I said, my mods are ready for you. No inappropriate questions. Just be a gentleman and don't ask inappropriate questions. And also, if you can't answer them, be a gentleman and accept the fact that he can't answer them. If he even wants to. He may not even accept your questions. I'm just saying. All right. Let's finish this video out. Let's do it. You guys are all awesome. Craig. All right. It will be civil. All right. Good. You can be civil. You are civil on my channel. I will tell you that. You are more civil than you're not. So I appreciate that from you. But like I said, he knows who you are. He may not answer your questions. So I'm not going to force him to. Just saying. All right. Let's finish this off. Hector, yeah, I know. I'm actually working on that right now. I'm working on a plan for screening questions. All right. Anyways, let's finish this video off. Like I said, I've got plans tonight. I got to hang out with my girlfriend. I got to hang out with my girlfriend. I mean, when I say I got to hang out with my girlfriend, I really want to. We haven't spent time together in like the last 48 hours, and I'm really looking forward to tonight. And it's already shortly after 6. So my time is very short right now. So I'm going to play the rest of this out. You guys are awesome. Thank you all for the super chats. Thank you all for the members. Craig, again, Craig, you're freaking awesome. Adam, thank you. Flying Monkey, thank you. Richard, thank you. Sallyport, thank you. Jude and Clyde, thank you all. You guys are all awesome. All right. Let's finish this off so I can, do my thing. All right. Until tomorrow. Bye.
Burglaries, grand thefts, criminal mischiefs.
Bond said 25,000. No contact with the alleged victim. Court date is March 11th at 9 o'clock.
Step to your right to the T.
Should have hit that preset.
Say your name.
William C. Jetty.
Mr. Jetty, before the court charged with tampering or theft of utilities. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Sir.
All right, sir. Have you already got a public defender on your other cases?
Sir. Yes, sir.
All right, they'll represent you on this case as well. I'm gonna set a $5,000 bond. Court date's gonna be February the 29th at 9 o'clock. Good luck, sir.
Thank you, sir.
Step to your right to the T.
Yes, sir.
Let it state your name.
Joseph Dow.
Sir, you're fully court charged trespass and a violation of probation for a felony petty theft. You understand the charges?
Yes, sir.
I understand you've been given copies of paperwork, advised of your rights. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Yes, sir.
All right, sir. On the trespass, your bond's $2,500. Your court date is February the 12th at 1 o'clock. On the violation of probation, you're held without bond. Your court date is March 13th at 9 o'clock. Good luck, sir.
All right, step to your right to the T. Next. State your name.
James Fucker.
Mr. Fox, you're fully court charged with violation of probation. Was originally burglary of non-occupied structure and possession of burglary tools in front of Judge Stevenson. You understand that, sir?
Yes, I do, Your Honor.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Judge Stevenson, in his infinite wisdom, is already held without bond. Your court date is February the 28th at 9 o'clock.
Excellent. Thank you,
Let's
sir.
step to your right to the T.